Imagine this. At 8 a.m., your receptionist hands you a stack of papers stamped summons. By noon, your operations team is panicking about this lawsuit, your CFO is calculating burn rate, and you're staring at a calendar that suddenly feels endless. How long until a judge or a jury decides the fate of your company? I'm Santiago Cueto, a board-certified international business attorney, and today we're mapping the real-world timeline of Florida litigation so you can turn months of uncertainty into a strategic advantage. Here are the 5 phases of litigation. Here's phase 1, from demand letter to docket, up to 90 days. Most business disputes simmer for weeks and demand letters fly, but once a complaint is filed, Florida defendants have 20 days to answer after the service of the lawsuit. Early motions to dismiss or compel arbitration can add another 30-60 days, but if they fail, the case barrels into discovery, and that's the next phase. Phase 2, discovery and case management. That can last up to about 12 months. Florida's differentiated case management order slots every matter onto a streamlined, general, or complex track. Streamlined cases, those under $50,000 with few witnesses, those get about 6 months of discovery. Complex cases can stretch for a year. New rules taking effect January 1st of 2025 align state procedure with the federal model and give judges tighter control over extensions, promising faster progress but stricter deadlines. The next phase is mediations and dispositive motions. These can take up to about 18 months. Nearly every circuit court orders mediation before trial. Success here ends the clock immediately. Failure sends parties to summary judgment practice. Since Florida adopted the federal summary judgment standard in 2021, judges are granting more motions earlier, trimming weeks or entire trials off the trial calendar. Phase 4 is the trial docket from 18 to 24 months, sometimes even longer. If no motion knocks out the case, you are in line for the trial calendar. Miami-Dade's business division, for example, aims for jury selection within 2 years, but statewide backlogs mean some venues still hover around the 3-year mark, especially for complex construction or class action matters. Nationally, overworked courts can see 4-year waits, and Florida is not immune from this. Now, phase 5, that's post-trial and appeals. That can go on for about 18 months. Post-verdict motions land within 15 days. A notice of appeal buys another 6 to 12 months in the District Court of Appeal. Factor in potential remand, and you can easily hit the 4-year mark from complaint to final resolution through streamlined cases with cooperative counsel. You can still wrap it up in under 18 months. Here are some variables that stretch or shrink the timeline. Venue choice. Collier County civil docket, for example, moves much faster than Miami-Dade's commercial division. Knowing where to sue can slash 6 months. E-hearings, remote discovery hearings, now standard, cut travel delays and speed rulings on routine motions. Case type. Injunctions, eviction actions, and probate contests enjoy rocket dockets, sometimes reaching trial in just 90 days. There's also judicial vacancies. A shortage of circuit judges inflates calendars. Statewide reports call for additional benches to tame that backlog. Here are 5 tactical plays to accelerate your case. Number 1, early summary judgment. Since the rule change, well-supported motions can end a lawsuit before depositions even finish. Number 2, agreed case management. Present the judge a joint schedule with aggressive but realistic dates. Courts reward cooperation. Number 3, targeted discovery. Use narrow, high-impact requests to avoid motion practice that burns weeks. Number 4, leverage mediation windows. Push for mediation when your leverage peaks. This is often right after a favorable discovery ruling. And 5, appeal bonds and stays. If you win at trial, a hefty appeal bond can dissuade the other side from prolonging the fight. Litigation in Florida can be a marathon or a sprint, by design or by default. Understand the statutory checkpoints, exploit the new federal-style rules, and drive the timeline instead of writing it. Because in the Sunshine State, justice delayed isn't just justice denied, it's capital. credibility, and competitive edge lost to the calendar. Master the timetable, and you'll turn that summons from a threat into the first move of a winning strategy before your opponent even knows what hour it is. If this breakdown helped you turn courtroom chaos into calculated strategies, hit that like button, subscribe for more inside track legal insights.